think we're on. I think we're doing it this time. Okay. Steven, thank you for kind of rectifying the problems. Guys, if you have any more problems, let us know. Steven's over here, so he will be checking your questions and your comments as they come in. Okay, and obviously feeding them to me. Okay, right. Going now to another question. What's the process of a divorce? It's a good question. Okay, I'm not going to get super technical with you guys because it's boring. It is. Because a divorce especially, the technical aspects of it are mostly paperwork. But one of the things you should know is you have to prove something called that the marriage has irretrievably broken down. And it can be broken down on 5 facts. Adultery, unreasonable behaviour, desertion, separated for 2 years, separated for 5 years. Okay? After which, most people, by the way, tend to go for unreasonable behaviour. Are we good?
We are. Apparently it's a lot better. Thank you, Anna. And okay?
Is that a lot better?
It is, yes.
Yay!
Hey.
Okay, fine. Right, so the process of a divorce is fairly actually straightforward because the first form you need to fill out is a D8. And the form actually, they've changed the form a lot now, and there's even rumours that you can do a divorce online. It's something that's being, I don't know if it's being trialled yet, but it's something that the courts are looking to do, that's in the pipeline. So basically, you know, apart from your name, details, date of birth, you've got to get a copy of your marriage certificate. So get, actually not a copy, but your original marriage certificate. And I know this sounds really daft, but when you're filling out the D8 form, they have to match.
Exactly. Do you know, we've seen people say to us that forms have been sent back if they've missed out middle names, incorrect spellings.
Yeah, you'd be amazed how many people can't spell their own name.
Or when they got married.
Or the date that they got married.
It's kind of an important
honestly,
thing. I think you remember.
I've seen it all.
Yeah.
Right. So look, either you're doing the D8 or someone else is doing the D8, but.
How do you do a D8 form? Very carefully.
Very, very carefully. Yeah, check and double check because the courts can be pretty anal and they will resend your application back numerous times until you learn how to spell your own name. Okay. There is a cost. There is a cost for a divorce application, and at the moment, I say at the moment because the courts keep raising their charges.
Usually, I think the last time they raised the cost, they actually gave people out 5 or 6 days' notice. If I remember, they were sending forms back to people, weren't they? Because the fees had gone up after a few days and they hadn't notified anyone. Anyway,
so the cost at the moment for a divorce application is £550. Fun fact, you can't sort out any financial aspect of your divorce until you've kicked off the divorce process. So unless you've kicked off the divorce process, okay, you're going to struggle with trying to work out a financial dispute. So I hope that answers that question.
What question are we on to?
That one.
What is the what is the process for divorce? That's what you've just been doing.
Yep.
Next question is, how do I know what a fair financial settlement is in a divorce?
Okay, well, finance is a bit of my baby because I know I look so nice, but way back in the day I was the debt collector. So
is it the old joke though? You've not got a tattoo on your neck, have you? That's one for Steve White, that is.
Anywho, anyhow, so the bit of legislation, again, I'm not going to get too techie with you guys, okay? You can Google a lot of this stuff. So the bit of legislation that you're going to need is Section 25 of the Matrimonial Causes Act.
1973.
That's going to be the factors that the court will decide how to divvy up assets and liabilities. So I'm going to boil this down to something really simple. So the factors the court are going to take into account are things like length of your marriage, how old you guys are there any children.
Factors not taken into account include behaviour.
Oh, well, it does, but not as much. In
extreme circumstances, isn't it?
Yeah, so and one of this kind of branches out from this particular question. So one of the questions I tend to get asked a lot is, yeah, but he was really mean to me and he was abusive or kicked me out of my house and all sorts. Basically, painting their other half to be the devil incarnate, which is quite tempting to do because that's why you're divorcing them.
And another factor which isn't taken into account is who brought what into the marriage.
Yeah, so let me just go back and explain that conduct really, really has much to do with the financial settlement. It is a factor, but depending on the severity of the conduct, really is taken into account.
Pretty severe, and probably more severe than you give credit for.
Yeah, absolutely. Yeah. Oh, and rule of thumb in any financial dispute, whether it be divorce financial settlement, as we're talking about here, or if you guys aren't married and you're trying to sort out a house or something, rule of thumb is money's going to follow the children. So if there are children that are in the marriage, not grown-up kids, by the way, okay, so I'm talking 16 and under, they will be given priority, okay, because their needs are obviously going to be greater than yours. So, fun fact, you can kick off any financial dispute after you've kicked off the divorce. So how do we know it was a fair financial settlement? Well, it's subjective.
It's not the word reasonable, isn't it?
It is. Or
consultation.
You know what? There's a strand of hair and we go to court and split that strand of hair,
fair,
unfortunately.
Fair is whatever you convince the judge is fair.
Yeah, well, yeah, exactly. Based, of course, upon the factors in under Section 25 of the Matrimonial Causes Act. I'm kind of just going to leave it there because... for sort of finances can be pretty boring. I mean, I like it, but
like nothing better than to go through a stack of bank statements that thick.
I know. I'm sick. I know. What can I say? But but for you guys, just to trawl through a pile of statements and what does it all mean? I think if you just bear in mind that
it's amazing how forgetful people get at hearings, don't they? They forget all sorts, large amounts of jewellery, cars. Houses in foreign countries?
Yeah, so my experience has been I've had to sort of uncover money that's been held in India or the large stack of 24 karat gold that they've forgotten they've hidden under the bed.
Or the regular outgoings of £5,000 into an undisclosed bank account.
Yeah, exactly. So listen, every trick in the book when it comes to finances, I've seen it, dealt with it, got the t-shirt. Okay, there ain't much I really haven't seen. Embezzlement, fraud.
What a fun life you lead.
Isn't it? Isn't it though? It's rock and roll, isn't it? Okay, let's move on to the next question.
I wasn't married to my ex, but we have a house. What can I do? Now, of course, first of all, this is not covered under the Matrimonial Causes Act 1973. So everything Michaela's answered in the previous question, ignore. It's entirely irrelevant.
Right, I'm going to talk a little bit about unmarried couples, okay? Because there's a lot of you guys out there that have been unmarried, but boy meets girl, fall in love, possibly have children, and you set up home as if you were a married couple. So that the phrase that I hear a lot is common law husband and wife. Doesn't exist. Does not exist. So
even if you
get it out your head.
Even if you wanted to, it doesn't exist.
Yeah, it really doesn't. Okay, I've heard it all. Okay, I don't believe in marriage. It's only a bit of paper. Yeah, wrong.
But the law does.
Wrong. Yeah, absolutely. So listen, guys. The practicalities of not getting married is together you're seen as just cohabitees. Now, you can argue with me about the rights and wrongs of that, but as it stands at the moment, there is no laws covering cohabitees.
There are people that are trying to change the law, aren't they?
Absolutely, there's a lot of campaigning going on to get that changed, absolutely right. But right now, when you get married, you see, you kind of join this club called the Matrimonial Causes Act, and it covers you for finances, but when you don't marry, that tends to leave in a big pit of nothingness. Because what often happens is the reality is you have a house, you have finances, there's loans, there's debts, just like you would have when you're married. So if you've got credit cards and loans and you guys aren't married, your only recourse really is to sue them in a civil court. And that gets tricky because you've got to show, if any of you guys have seen Judge Rinder or Judge Judy, that's the area that we're talking about. Okay, so you have to ascertain whether or not it was a contract. It all gets kind of messy. Houses, however, are a little bit more simple. I say simple, but you do have some kind of recourse if you guys have owned a house. Now, what often happens is there is a house, it may or may not be in joint names, and one of you, either of you, may or may not decide to sell the property, or there will be a dispute about what happens to said property. As it happens, you are covered under something called TOLATA, Trusts and Land Act. So, again, I'm not going to get techie with you guys because it won't stick it in and it'll just fry your brain because Lord knows it fries mine. But basically, you've got a piece of law, a statute that covers you so that you can take the matter to court to get this matter resolved. Now, the court don't like you actually to go to court, and they'd much prefer you to go to mediation first. And in fact, in a lot of instances, mediation for anything really has to be your go-to before you go to court. And from our point of view, guys, if you could settle this over a cup of coffee, you probably wouldn't be watching this video right now and be interacting with us now. So there is recourse out there for you, okay? And again, with anything to do with money, money follows the children, okay? So if you've got kids, I'm going to talk about kids that are 16 and under, and if they happen to live in the house, usually speaking, any judge is probably going to fall backwards to keep the kids in the house, to maintain their stability and routine, okay? But look, this is the real world, you know. If the house has been in arrears and it's practically near repossession, something is going to have to happen with that house. The house is going to need to be sold, and effectively we're asking the court to kind of intervene and help us out with that.
Okay, well, we've had a question come in,
Okay.
live question for you.
Yeah.
And the question is, if a CAFCASS puts a recommendation in concerning visitations,
Yep.
Can you disagree with it in a final hearing and set out your own schedule? And the answer to that is yes.
Yes.
It's simple as that. You know, CAFCASS write a report, typically it'll be a Section 7 report, sometimes it's addendum reports,
Yep.
and they are just that, they're recommendations. The only person that can make the order is a judge or magistrates if you're before a magistrates court. Now, the court very often goes with CAFCASS recommendations, but what will typically happen is that you will have an opportunity as a final hearing to ask questions of the author of the report to establish that, well, whatever you want is the better thing, the best interest of the children. So yes, absolutely. You know, you have an opportunity to question the CAFCASS officer.
Yeah.
You know, do you know what? It does happen quite often, doesn't it? That we manage to assist people to change what are court orders. They won't go with the CAFCASS recommendations.
Yeah.
It does happen. It's not unheard of by a long shot.
No, absolutely. And I've been in many cases where we have overturned CAFCASS recommendations. I think your key here is a couple of things to bear in mind. Check the report. Make sure there are no holes in the report. Usually it's helpful if the CAFCASS officer visits you and children.
Yeah, definitely. And in fact, I think there's even case law for that, isn't there? That if a parent has not been observed with a child, that the CAFCASS report is of limited value. I think that can be thought, isn't it?
Yeah, but again, not knowing your full situation, if contact with children have been suspended for quite some time, obviously it's going to be difficult for CAFCASS to monitor it and to supervise it, you know. So, but on the whole, they need to have seen you together, and then check the consistencies. The other thing I would say to you is make sure that for any final hearing you have a bundle. Now, you guys have heard me bang on this, like, oh my god, she's going on about the bundle again. Oh yeah, it's my favourite. Bundles. It's my favourite drum to bang because, oh my gosh, without your evidence in the bundle, it's a bit pointless. So if you're being accused of X, Y and Z, well, make sure you've got stuff in there to substantiate your case, okay? Often, not all the time, but often those bundles tend to be a bit of a copy and paste exercise where, I don't know, somebody's just copied all the orders.
Yeah, just orders, statements,
application
reports.
Yeah.
Nothing that you won't have seen 1,000 times before.
Yeah. Yeah, so make sure that your evidence is in the bundle. Now, you can either attach that to any statement if you're not preparing the bundle, or if you are preparing the bundle, make sure it's in there.
Yeah,
okay?
your bedtime reading is practice direction 27A.
Good luck.
Okay.
Yeah.
Next question. We have a question from Beth here. If you were to go to mediation, where would you look? There are so many options out there. It is a minefield.
You're absolutely right.
Okay, so I mean, the simple answer to that is Google is your friend here. If you're the non-resident parent, you find a mediator close to where the resident parent lives. And when I say resident parent, I don't mean there's an order in place. I mean the person who currently has majority care of the child.
It's a primary carer.
Yeah, primary carer, yes. That's a better term for it, yes.
Yeah.
You do that and you basically Google's your friends.
I would also ring and speak to some, because you know what? The one thing I've found with mediators is there are like a bajillion ways. There are a bajillion ways that they're going to decide to deal with people. They'll have different areas of expertise, and their charges. Oh my gosh, their charges really, really fluctuate. Now, sometimes, if you know that mediation is going to be an absolute disaster. For example, if you know, that your ex won't sit in the room with you, it's going to be a lot more difficult to find a mediator that is going to facilitate something called shuttle mediation. Yes,
I've never done it. Do you know, all the years I've done it, I've never actually known anyone that's done shuttle mediation. Have you?
Yeah, it's not common. It's not.
Have you known anyone?
Yep. Yep.
I've never known it to happen.
Yeah, but it's expensive because, well, there's just a lot more involved practically.
But it's still cheaper than going to court.
Overall, it's still cheaper than going to court, absolutely. And yeah, so Google's your friend. Ring around, talk to them, just like you would pretty much with any professional. Make sure that you're comfortable with who you're dealing with. Okay,
next question coming in. The question is from Sam Devereaux. My 8-year-old doesn't want to see her dad or spend time with him for many reasons. At 8, is she able to make that choice in the eyes of the law?
Great question, really great question. So before, there used to be an age set when a child could or could not express their wishes and feelings. Well, that kind of went out now. That's long gone. That kind of went out with the dinosaurs. Now, a child's wishes and feelings are based on their age and understanding. And
yes.
I can see the logic for that, because you can get a really intelligent 8-year-old who absolutely gets it, absolutely knows their own mind, is switched on, totally knows their own mind, and understand, more importantly, what's going on. But similarly, you can also get a really young 11-year-old who, you know, just young for his age, and their understanding and their maturity isn't the same. So I can understand the logic why they got rid of what was called Gillett competency, and I can understand why now it's based on age and understanding. What I would say, though, is if an 8-year-old doesn't want to see another parent, you've got to ask why. And the courts are of the view that, look, it might be her wishes and feelings, but that's not going to be, and I quote something here from the court, the determinative factor in any welfare checklist. In other words, first of all, you've got to ask why, okay? And that's the one reason the court's going to ask.
Yeah, they will want to know why. And you know, it's also worth remembering that children are subject to the Children Act, which means the court will make an order. So, I don't know, even technically, a 15-year-old or a 15-and-a-half-year-old or someone who's a few months before their 16th birthday is still subject to the Children Act. Yeah,
so you want to make that fine balance between, look, what's really going on here, and there'll be professionals like CAFCASS or local authority to investigate why doesn't she want to see her dad, but also be mindful on the flip side of that. You know, look, kids will probably want chocolate for breakfast, lunch and dinner if you let them, but you don't, because it's not in their best interest. Now, I know I'm being flippant there, but my point is, look, just be mindful that that your daughter's not trying to gain some advantage, because kids are great at playing one off against the other. They're masters of it. They'll say one thing to one parent and another to another,
whether their parents are separated or not. Okay,
yeah.
So next question from Bex. Can you provide your own bundle even if the responsibility has been given to the other party? That's a great question, and this is, once again, this is, I'm usually the ranter at the two of us. But bundles, Michaela gets a glint now.
I do.
Now, the way it works is that if both parties are represented, the applicant is responsible for the bundle.
Or the person that is represented is responsible. So you'll probably have an order that says what the other party is going to do the bundle. But if you have a look, again, I'm going to quote Practice Direction 27A. Learn it, know it, recite it.
As Captain Jack Sparrow says.
Well, no, we have the kind of guidelines.
Yeah, more of guidelines.
But listen, you know what? The bundle is often a source of controversy. It is what it is. It's a source of controversy because they're not going to want to put something in that their client makes them look bad. Okay, so if you read the wording of Practice Direction 27A, what it actually says is that the bundle contents have to be agreed.
Where possible.
Where possible. How many times do you think bundles get agreed?
Whoops. Admin errors.
Lost evidence.
Yep, and then you turn up to a trial with no evidence at all. You've seen it happen.
Exactly. So, look, they're supposed to consult you. And you have to let them do that.
And what's the definition of consult?
Well, again, strand of hair scenario. But they have to, look, let's be real here. They need to tell you, would you like anything in the bundle? Please send it over.
And then we'll put it in the bundle.
Yeah, now obviously they have a right to disagree. But if they're trying to, and this is key, if they're trying to frustrate the bundle process, well then you've got a different problem. Because rather than just, first of all, whacking your own bundle, and by the way, I'm more than happy doing our own bundles, okay, if it helps, but you need to say to them, look, you're frustrating bundle process here. Quote the relevant Practice Direction 27A. More importantly, you send that letter as also to the court. If you haven't got a bundle a few days in advance, I'd start worrying. And if it's a bundle there and they've ignored all your evidence, now there are guidelines in Practice Direction 27A that will tell you exactly what can and cannot go into a bundle. Again, check it out, because there'll be certain things that you have to have the court's permission for. Things like, off the top of my head, things like contact book entries, etc. You can't automatically whack that in a bundle. But if you've got emails and texts, etc., that are going to substantiate your case, then absolutely they're going to need to be put in. And yeah, you guys are sick of hearing this from me.
It's also worth remembering that if you raise this issue with a solicitor, the solicitor will typically advise you, okay, well, we'll wait until we get to the hearing, and then we'll raise it with the court, and the court will make a decision. Now, believe me, we don't recommend that. You know, we do differ from solicitors that, because typically, if you wait till you get to the hearing and your evidence has not been included, or you haven't been given a bundle and you raise it with the court, if you're lucky, the court may adjourn the hearing for half an hour for you to read through the bundle.
Yeah, exactly.
Because, you know, the court is concerned with the best interest of the child, and one of the big factors the court will always consider is the impact of delay on making a decision. So, you know, I would say don't chance it.
Yeah, I don't chance it. Make sure there's plenty of communication between you and the court. And make sure that you're sending any evidence that you want put in the bundle. Make sure you're sending that.
And make sure you have evidence that you've sent the evidence over as well.
Yeah, because I mean, believe it or not, I've seen fake emails, fake IP. Oh God, we've seen it all, haven't we?
Yeah, we're somewhat cynical on this, aren't we?
Yeah, yeah.
Okay.
Yeah. Okay.
Next question, one from Beth. How does a court request their child is heard in court? As I've had friends refuse this.
Kids don't normally attend court. Okay, that's just from the get-go.
Yeah, because much as anything else, you shouldn't involve them in the court process.
Absolutely. That's why we've got parents, that's why we've got professionals, that's why we've got judges, is so that the children themselves aren't subjected to that. Having said that, I know lots and lots of cases where the judge has taken a particular interest in a case and will actually ask to speak with the child. And I've known many cases where that's been the case, where actually the child has turned up and has gone into the judge's chambers and spoken with the judge.
But there is a really formal process for it as well, isn't there? And that's the appointment of a guardian.
Absolutely, yeah. So the appropriate way that this should be dealt with is for an appointment of a guardian under Rule 16.4. That's when the child will have their own representation. So effectively a guardian, it's usually CAFCASS, or it could be the local authority, or even NIAS, National Youth Advocacy Service, will kind of befriend the child, and their wishes and feelings are then presented through their own solicitor in court.
So what happens if you get to a hearing like that? You'll be there, with or without your solicitor. Your ex will be there with or without their solicitor, and there will be a solicitor representing your child. So there's 3 parties.
Yes, it'll be 3 parties. And when you have a look at the response, you'll have applicant, first respondent, second respondent. And also, FYI, babies, because we deal with both public law and private law, in some cases, babies can be added in as part of the proceedings as well. So,
why is it that they appoint guardians?
So there's a checklist. There is a checklist. You can't just say, well, I just want a guardian appointed so that the child's wishes and feelings are being heard. So one of the main checklist is that there's going to be implacable hostility between the parents, and if the child's wishes and feelings cannot be represented properly by either parent. Now, in a typical scenario, and I'm broad stroking here, but what you're going to find is you're going to find a parent, sometimes it'd be the primary carer, usually the primary carer, may be very hostile, for example, to the other party having any contact with the child. And then there is an argument to be had there that that the primary carer cannot possibly represent the wishes and feelings or represent the best interests of the child because he or she is implacably hostile to the other parent, and then the other parent can't reasonably be expected to represent the child's best interest because there's probably no contact there.
Yeah, I would say, going back on it, Beth, the child's opinion is represented. Typically, where there's a CAFCASS report under a Section 7 report, the CAFCASS officer will speak to the child. If there's something like a psychologist report or play therapy, the children are spoken to, so their opinion will be represented. It's as simple as that. How much weight attached to the opinion, once again, goes back to a lawfare checklist detailed in Section 1 of the Children Act, ascertainable wishes and feelings depending on age and understanding.
Well done.
I almost said I know what I'm talking about. Okay, so next question. Was it Brian Mack? If drugs are brought up at court, what is the probability the court will test? And a person is a recovering addict with clean, regular mouth swab tests. And what happens with the results?
Okay, well, great question. For a start, we see this a lot, like a lot. So I'm going to bundle drugs and alcohol into this as well because they often go hand in hand. But to answer your question, rule of thumb, the other side is going to want you tested, obviously, but actually it has to be exceptional for there to be a drugs test. So I just want to talk a little bit about the drugs test itself if the court orders it. So first of all, you can't just get any kind of kit off the internet. You can't just rock up to any place and get a drugs test. That's the first thing.
Strictly speaking, unless it's actually been ordered by the court.
Yep. So if it's not been ordered by the court, forget it.
Even if it's a legitimate, accredited drugs testing company, it can be rejected by the court because it's not been ordered.
Absolutely. So I wouldn't bother. If it's not been court ordered, don't bother. Secondly, if the court has ordered it, it has to be an appropriate body recognised by the court. So one of the ones that I know off the top of my head is a company called LexTox. Third thing...
Cansford Labs is one we use.
Oh, yeah.
They're pretty good.
Yeah. Third thing, man, it costs. Like, it costs a lot. And depending on a couple of things, depending on what drugs are to be tested, and then how far back
because they can do they can do like an average test, but they can do a sectional test at 3 month segments as well.
Absolutely.
Which costs even more. Yeah,
and I've had it gone back, the last time I had it was going back 6 months.
And if they send a collector out to collect the hair, that costs even more.
Yeah, so, man, there are costs involved. So, if it's not necessary, it is not necessary, because in an age of where we are now, not many people have got that kind of money just to hand like that. So often I would put the argument forward that if you've got regular swabs and you've got a letter from your GP to substantiate, and if you're recovering, you'll probably be involved in some kind of programme, a letter is going to substantiate that.
Okay, another question from Beth. How do you get a guardian appointed? Leading on from the last one. The flippant answer is convince the court it's needed.
Yeah, well, it needs to be recommended, although so it can happen in 2 ways.
You can ask.
You can ask, okay, and if I think it's appropriate, I'll get people to say, we need to ask for this, under Rule 16.4, or it can be recommended by CAFCASS, or the local authority. So in brief, that's how it gets done. And then the court will then, there'll be a process of where the judge will appoint a solicitor and a guardian and check availability and check on reports. So there's a whole kind of timetabling. But the two ways you ask for it will be ask yourself, and that can either be in your submissions, although I'd recommend you put it into a position statement first. You've got to substantiate your reasons as to why. Don't forget the checklist I've just talked about. Or it's recommended by the person doing either a Section 7 or, if you're really lucky to have something bigger, a Section 37 report.
Okay, so I think we need to move on to one of the more questions we've got emailed in over the last few days.
Okay, right.
Okay, there you go, that's a good question. I wasn't married to my ex. Oh no, I'll cover that one. Can social services take my kids off me?
Right, okay, this is a good question, okay, and it's one we've heard quite a lot. So as you know, we deal with both public law and private law. Sometimes when you talk to people, you'd swear that social services has knocked the door down at 3 AM and taken kids off people.
Without warning.
Absolutely. The reality is that's not the case. You would have had some notification that something was going to be on the cards. Issues will have been raised. That's the first thing to acknowledge. Issues will have been raised by the local authority, and I'm not going to open a can of worms on this. So I'm just trying to think of a ways to not to open the can of worms on it, because otherwise I'll just go down this rabbit hole and you'll be pulling me out by my ears. So social services can either do something called a Section 20, where they persuade you that your children are better off in care.
Of your own free will.
Yeah, and they'll get you to sign a piece of paper. So that's one of the ways they do it.
They can't make you sign a piece of paper.
No, although they may
suggest that if you don't sign a piece of paper, they'll be able to remove your children with other means.
That's very well put.
And then the bottom line is social services have got no special powers to remove a child. If the social service wants to remove a child, they need to get a court order like anyone else.
Yeah.
In fact, you know, the only people that can remove children without an order are the police.
Yeah, absolutely.
But once again, that's under extremely limited circumstances.
Yeah. So I mean, they could do the local authority if you won't be persuaded to have your children taken into care, they can do something called an emergency protection order.
But it's an order once again, isn't it?
It's an order.
There'll be a hearing for this.
Yeah.
Okay. So
yeah.
Next question. How can I represent myself? You know, it's funny. We do this all the time.
Yeah.
And after a while, you know, sometimes we've forgotten that people don't realise that they have a legal right to represent themselves. They'll say, I didn't know I can represent myself. I thought I needed a solicitor.
And I suppose this is what makes the Q&A really good, because actually it's pretty good for us as well as you guys, because yeah, some of the questions that seem really obvious to me and you aren't.
Yeah, well,
really.
I guess it's normal, but yeah, which is why it's good that we actually have questions like this.
Yeah, keep it real. Yeah, so how can I represent myself? Well, you can. You've got a legal right to represent yourself, and this is what I will say. I'll always say, look, you are the case. You know who, what, why, where, when and how, just like that. And that's to your advantage. You don't have to rely on a third party to remember those finite details. Often what you need, though, is guidance. And
yeah, because that's the downside of representing yourself. Because you know what? It's hard to stay impartial when it comes to your own kids. And you know what? You've probably got a whole host of reasons which may or may not be relevant to your case as much as you might feel they are.
Absolutely.
I mean, which is the reason why people use solicitors after all, because the solicitors are impartial and they'll present things to the court that they know that the court, or they should know, are actually relevant to the case to push your position forward.
Yeah, absolutely. Yeah, really well put.
Yeah, and you know what? A question we always get asked actually is, Mackenzie Friends, why the hell are Mackenzie Friends called Mackenzie Friends? And the simple answer was that in the 1970s there was a court case where a man decided he was going to represent himself. His name was Mackenzie, wasn't it? That was why. And he used a friend who happened to be an Australian barrister in London to assist him, and the court threw him out on the grounds that he wasn't a solicitor. So he appealed, and he won the appeal, and henceforth the name for an assistant was a Mackenzie Friend.
So, you know, this ain't nothing new. I mean,
it goes back to the 70s, doesn't it?
Yeah, absolutely. Yeah, and then Mackenzie friends have been around really since then.
Okay, Bex, kitchen. What's the best way to get no contact when there are concerns, risks already been identified, but CAFCASS are adamant supervised access in a contact centre is appropriate? Is it possible to get no contact even when CAFCASS don't agree?
Okay.
It comes back to the other one about CAFCASS reports. The answer is you convince the court that what you're seeking is in the best interest of the child and CAFCASS are wrong.
Yeah, pretty much. Yeah. So usually the court will have to have substantial reasons to depart from what CAFCASS have recommended. Okay.
It does happen, as you said.
Yeah, absolutely. You know, and I don't always see the judge agreeing with CAFCASS. So bear that in mind as well. Just because CAFCASS think it doesn't always necessarily accord with what the judge thinks. And again, I don't know if you've got an upcoming hearing, I would suggest that that's a great opportunity to challenge that report. So one of two ways you can challenge that report. In a final hearing, quite simply, you get them on the stand, you cross-examine them. It's as simple as that. But if you haven't got a final hearing coming up, then you can raise objections to recommendations in the CAFCASS report. But don't forget to substantiate it. Another thing you're going to learn, know and recite is the welfare checklist. Because everything is based around that. So again, hence why I say learn.
Exactly that, and that's a great thing. When you do anything, when you think about anything, when you write anything, when you say anything, everything should be in relation to how it bears on the welfare checklist.
Yeah, absolutely.
And if it's not in the welfare checklist, don't use it.
Yeah, absolutely. So, because CAFCASS would have done their report around the welfare checklist.
It actually says that in the report itself, doesn't it? It usually says, I've taken into account the points raised in the welfare checklist. It's usually at the bottom of the report, isn't it?
Yeah, absolutely. So make sure you've got stuff that can substantiate. So I'm talking GP reports, police reports if you have them, because there's going to have to be something really bad for contact usually to not happen in any way, shape or form.
At any point.
At any point, yeah. So it's rare. It's not unheard of, because I've been in lots of cases where the court has ordered no contact. But again, you couple of things you're going to have in your toolbox to make that happen. First of all, is the professionals. Use the professionals. What you reckon, if it's just one of you, you're going to need people on your side. So again, I'm thinking police reports. I'm thinking GP reports. And again, if you can get professionals on board, way to go.
And you know, it's also worth remembering that if that's what you're seeking, but every other professional disagrees with you, you risk being told that you disagree with all the professionals.
Yeah.
It's just funny enough, you know,
it's a fine line.
When we're on the other side of the fence, when we're helping the parent who wants contact, you know, we've got a whole set of interesting questions that we can use to actually prove that you lack insights, you're not child focused, and you know, you're not thinking of the future.
Either way, it doesn't matter which side of the fence we've acted upon. I will say this: is just be prepared for the inevitable questions. So, like I said, make sure you get tools in your bag. Okay, present it in a bundle, present it in a position statement, and if you've got an upcoming final hearing, you can challenge this report. That's the whole point of it.
And Beck's welfare checklist, it is section 1 of the Children's Act. If you Google welfare checklist, it's all over the place.
Bunch of stuff.
You'll get the list of it. And if you really want to read the Children's Act 1989 and the
I
amended version,
seriously, God, it's like this.
Yeah.
Yeah. So.
Okay.
Yeah.
So I think we need to move on to another question from email.
Okie doke.
So this question: why won't my solicitor listen to me?
Yeah.
Because you know this is a thing that many people come to us.
Yeah.
They'll often say, do you know what, I paid my solicitor and I told my solicitor all the things that were important to me, and they sat there and they ignored everything I said, and they didn't tell the judge everything the judge needed to know. Now, do you know what? I hate to say this, I've got some sympathy for solicitors. I know, you can't believe I'm saying it. Do you know what? There's good and bad in everything. So, some solicitors do actually get quite a hard rap on this, because you think about it from a solicitor's point of view. We just mentioned about the welfare checklist, for example. If you think that the court absolutely needs to know that, your ex's mother was a drug dealer back in the late 60s, but she's moved to Australia and never been heard of since, the solicitor probably isn't going to mention that because it's not relevant, even if you feel it's important.
Mm-hmm. And actually, you know what? It kind of accords with what we deal with on a daily basis. You know, there have been times where, I'll be real with you guys, there have been times when I've come out of court and I've said, which bit of X, Y, and Z to not say wasn't clear. Okay.
Do you remember as well, do you know what, a lot of these court hearings, there's an awful lot of waiting around, and there's not an awful lot of time actually sitting in front of a judge or magistrate, which means you've got limited time, so you really don't want to bury all the good reasons you've got amongst stuff that the court isn't going to be interested in. And do you know what? I've seen no end of hearings where there'll be someone who will be telling the judge exactly what they think, and they'll be, I don't know, telling a really long story, and the judge will be like this. Anyway, moving on to this, and this, you've wasted your time. So, you know, we want you to say everything that's related to the welfare checklist, everything that's actually relevant to your case, and most solicitors will want the same sort of stuff. And do you know what? Yeah, that's what solicitors do. Yeah.
I mean, of course, having said that, of course, there are, you know, solicitors, if you don't feel that are listening to you, then, you know.
Yeah.
You know, yeah.
Okay, so what involvement do CAFCASS have in a custody case? Okay, first of all, it's not called custody.
Thank you.
Since 1989, that's when Milli Vanilli were in charge. You know, girl, was it Girlie, I'm going to miss you, or Girlie, I don't know.
How do you even remember that?
I don't know. Google is your friend.
Yeah, so listen, guys, this isn't Kramer versus Kramer. Okay, so let's get off, put that way. What was the question?
Anyway, what involvement do CAFCASS have in a custody case?
Quite a lot, actually.
Okay, well, CAFCASS will always, CAFCASS will always be involved initially.
Yep.
When someone makes an application under the 1989 Children Act, CAFCASS will always do a Schedule 2 letter.
Otherwise known as a safeguarding report. And effectively, that report is going to be split into various sections. So you'll have a brief phone call from CAFCASS at the beginning. So somebody lodges an application. One of the next people that you're going to hear from is CAFCASS. So before they've even gotten on the phone to you, they will have already done a background check.
Yeah,
so they will check police, they will check social services, anything else that is outstanding. They'll give you a call. They'll give the other side a call. And then they'll have like a shortish report, probably consisting of no more than about 6 or 7 pages. And it'll be documented. So they'll be documented what, if anything, has come up on the police national computer, whether or not the children are known to social services. What are the concerns you've raised? What are the concerns the other side?
What do you both want?
What you both want?
That's normal. What always happens. It's also worth remembering that if you get to the hearing and that report's not been done, and it does happen from time to time, the court will typically either adjourn it or say we can't do anything and go away for a few weeks. I've known a few hearings I've done where I've turned up with people, and the first thing the judge says, there's no welfare, there's no Schedule 2 letter. I'm going to adjourn this for a couple of weeks.
So one of the most important parts, the important part really, that safeguarding report is going to be the advice to the court, because they're going to really determine how the case progresses. And then, just to add a little flavour into the mix, some courts have CAFCASS on site. Now, I'm a fan of it. It would be lovely if all the courts did the same thing. It'd make our lives a heck of a lot easier. But you know what? They don't.
They do that in Newport in Wales. I know they used to do it in Doncaster.
They do it in loads. They do it in those courts. But it really, really depends. It's a bit of a lottery.
It's good if it happens, isn't it?
It's great.
Because they drag them downstairs. Come and speak to us in court.
So your first hearing, if CAFCASS are going to be at site, and you'll probably know this actually because it usually says on the court order.
There's also a conciliation, isn't there?
Well, that's supposed to be what the first hearing is supposed to be. So you'll have CAFCASS pretty much playing like mediator between you guys, and then what you'll find is they'll at court they'll take you into a room and have a long chat. They'll take the other side into the room and have a long chat.
And see if they can get you together. They'll ask you.
Absolutely, and see if they can thrash something out. Because look, the courts just really want you to go away. So if they can come to some kind of agreement, great.
And then there is a second report that CAFCASS can do, and this is depending on if they think there's any welfare concerns.
Yeah.
They'll order a Section 7 report. Now, that's when CAFCASS will be involved if the children are known to social services prior to the case. Normally it will be a Section 7 report, but actually usually done by social services. But it's the same sort of report, just by different agencies. CAFCASS will typically, they'll do a deeper exploration of any involvement with the police and social services. They'll speak to both parents, they'll observe the children with both parents, and then they'll make recommendations based on the report. And as we said before, these recommendations do not need to be followed by the court. They quite often are, but you will get a chance to cross-examine the author of the report and challenge the report if you don't agree with it.
Yeah. So, yeah.
Yeah. Okay, so let's see. Andy Duvet, what do elephants dream about? Thanks, Andy.
Oh my God, there's not even any wine in here.
What do elephants dream about? I don't know, probably, trampling people?
Dumbo.
Squirting water?
Yeah. Circuses.
Yeah. I don't know.
I hope that answers it, Andy.
Good question. We did say
valid
this.
question.
We did say this. Right, okay, so next question here. Can I make an application to see my grandchildren?
Yes. Yes,
hey, excellent. You can. Glad we covered that. Would you like to expand on this, Michaela?
Yes, you can.
Almost exactly the same process as parents.
Yeah.
With one significant difference.
Grandparents don't have parental responsibility, so you still can make an application, and you still have to follow mediation, but you have to jump through another hurdle because you don't have parental responsibility, so therefore you can't automatically make an application to see your grandchildren. So you'll have to fill out an additional form called a C2 as well as a C100, and the C2 form is to ask permission from the court to make the application.
That's right.
Now, in all reality, you just file both forms together.
And there's no additional fee, it's just a standard fee for C100, isn't it?
Yeah. I know I'm being a bit anal here, but a lot of people say to me, do fathers have rights? Do grandparents have rights? And the simple answer is no, because you don't get the Fathers Act 19 whatever, you don't get the Mothers Act 19 whatever, you don't get the Grandparents Act 19 whatever.
Something else that was abolished in 1989, the natural role of the father as the guardian of the child is abolished.
Yeah, but you do get the Children Act, and the children have a right to have a relationship with both the maternal and the paternal family. So yes is the short answer to your question.
And when it comes to a C2, the benchmark of a C2 is how much involvement has the grandparents have with the children.
Yeah.
So if you're involved, then yeah, you'll get permission. If you're not, and I don't know, the kids are 14, you've never seen them, you're probably not.
Well, no, actually, if you're a grandparent, you'll probably get permission. If you're if you're not a relative, you have to show how much involvement you've had. Step parents, for example, would have to show that.
Yeah. Okay. Next one. Can I use recordings in court?
Oh, great one. But we hear this a lot. Okay. No is the simple answer. In all the years I've been doing this,
there's nothing to stop you though, is there? Is there?
Yeah. So courts, for some reason, listen. Let me backtrack. In all the years I've been doing this, I've only had video and or audio evidence admitted twice.
It happens. It's a big risk to gambler, isn't it?
It is. For some reason, the courts will happily have something transcribed, i.e. written in paper, on paper, not in paper, on paper. But if it's audio or visual, they don't like it. Often, what I would tend to do is use it more as a pawn, okay? Because if you have recorded something, be careful, because if you start whacking in, obviously it depends on what it is. I mean, if you've got somebody breaking a glass over your child's face or something, that's, for starters, should be a criminal matter anyway.
Yeah, bad example probably.
Yeah, really bad example.
But look, the point is, you know what, like I say, it's a big gamble whether recordings will be allowed to be heard or seen in court. Transcriptions are much more likely, so that's why you should always transcribe them. And do you know what, if the other party disputes and says that transcription isn't accurate and you've got the video or the audio to hand, well, you know what, like you say, it's always there.
Yeah, and again, look,
don't rely on it, okay?
Yeah, don't rely on it, and common sense will dictate here. There's a reason why our Practice Direction 27A for bundles only has a limit of 350 pages. Okay,
next question. Is it possible to apply to court for a step-parent to have parental responsibility?
Yes.
Yes, it is. Okay, so the process, first of all, is you go to... Okay, for someone to gain parental responsibility of a child, all existing holders have to agree to it. It doesn't need to be written, but it needs to be agreed, don't they?
No, it needs to be written.
Does it? Okay.
Yeah.
How many parents? Isn't it something like 14 people can have parental responsibility for a child?
Up to 6 people
Up
can
to
have.
6 people.
Up to 6 people can have parental responsibility for a child.
Okay, so what will happen is if you want someone else to have parental responsibility for a child, you ask them to fill in a CPRA01 form, and they will fill the form in, and you send it to court, and they make an order for parental responsibility. And the step after that, if they don't agree, you make an application to the court.
Now, listen, guys, not many people are going to agree for either, as an example, the new partner to have parental responsibility for a child. So it often requires a separate application to the court to make that happen. To have it granted by the court, you're going to have to show that the person you want parental responsibility must show that they're involved with the child's life, they've got a meaningful relationship, and you have to justify why you want another person to have parental responsibility.
I think it helps usually if the parent with PR is not involved. So if they've, I don't know, they've vanished to the other side of the planet, it makes it more
yeah, you're right. So that the absent parent, that's one example. Yeah.
So the answer is yes.
Yes, basically, yeah.
Okay. So next question is, can I claim costs of the ex?
Oh God, yeah.
And once again, yes. But
in exceptional circumstances. So family law, in any other area of law, especially civil, if you're trying to claim costs, then the loser will have to pay the costs. But it has to be in exceptional circumstances.
And there's a really, really, really simple reason for that. In courts involving children, they've only got one concern. That's the best interest of the children. So you have to prove that costs being awarded to a parent were in the best interest of the child.
Listen, and let's keep it real. You know what? They don't want to pour petrol on the fire. Family law is already adversarial and emotional as it is. It really doesn't do anybody any good to award costs. So it's a simple answer to that.
Okay, and the next question is, can I sue my ex for defamation?
Yeah, we hear this one as well. Practically, no. No. For a start...
Well, okay, I think of 2 easy reasons. Once again, it's the same as a previous question. Best interest of the child. Best interest of the child. And secondly, the courts are private.
Absolutely. Now, don't get me wrong. If I had £1 for every time someone said to me, well, she lied under oath, I'm like, yeah, she probably did. So if we come across a little blasé about it, it's simply because we have seen it bajillion of times. The courts have seen it bajillion times. But you are not likely to get any success. We know, and we get it, but from a practical point of view, no is probably the answer you're looking for. You can't sue your ex for defamation of character in a family law court.
And you know what, it probably isn't worth it. No, really,
the only person that's going to win is probably a lawyer if they take a case on.
And you know, if you've got a court case, this is effectively another court case. Do you really want to be fighting another court case?
Or in conjunction with the case you're already fighting.
For your children.
Pick your battles, and that ain't one of them.
Okay, next question is, if you manage to get no contact orders, is it possible to have their parental responsibility removed? And is it even worth it? Once again, you have to convince the court.
Yeah, you can get parental responsibility removed, and I know of cases where that's happened. But again, I'm going to refer you back to welfare checklist, okay? So let's talk about the welfare checklist. So you would have to show that it's against their emotional, educational, to do with their heritage and roots, their stability and routine, things like that. You can absolutely remove a parental responsibility. It's rarely done. I've seen it done. I've been there when it's done, but it's rarely done. And in the circumstances that I've been involved in where that's happened, the parent has created that much abuse that it's not been, that they've had no contact, and and then the court, he's acted despicably, and that parent has had their PR removed.
But you'd have to convince the court that by not making the order that the child comes to harm. It's the no order principle.
Yes.
The court is not going to make an order
Yeah.
if it feels that it makes no odds to the children.
Yeah.
So you've got to convince the court that if the court doesn't make this order, the child is going to be damaged or adversely affected in some way. The onus is always on you to prove that an order should be made.
Yeah, absolutely. Because the courts actually don't like making orders, and that's why you've got the
and it makes sense really, because the court doesn't want to get involved in people's families and people's children.
Yeah.
Really, the parents should be able to agree things between them, and the court. It's not the court's job to arrange how people parent their children.
Yeah, but obviously we appreciate the reality of this. Yeah.
Okay, next question will be: can I ask for another judge in my case?
No.
No.
No. No, you can't. Just because you don't like what he or she reckons or what he or she said in court. Courts and actually family law courts and professionals in the family law court are very difficult to read often, because often they're playing devil's advocate. Secondly, your perception of what's going on, I guarantee you, is going to be very different to somebody that's objective. Guaranteed, and I've seen this a bajillion times, guaranteed if one party's getting a bollocking, be prepared for you to get a bollocking as well. Okay, so actually, in terms of how they deal with the case, it needs to be fairly even-handed. Don't get me wrong, I've seen practices where that's not been the case, and I've had people come to me and go, oh my God, I'm in front of Judge so-and-so, he absolutely hates me.
Or they will say to us, well, this judge, what's he like?
Yeah. Yeah, and that's really difficult, because each case to its own,
each hearing. We've done, we've assisted in some cases where one hearing, the judge appears to be your best friend in the world, and he's a really nice guy, and you know what, he's really taking a shine to you. In the next hearing,
he's slating you.
He's slating you the moment you walk through the door.
Yeah, exactly. So, no is the short answer to that. Pretty much. And that goes the same actually with family law professions as well. Can I change my CAFCASS officer? No.
Conversely, though, you can ask that a judge stays on a case. Reserves the case to himself.
Yeah,
or herself.
For judicial continuity. And there's lots of cases where I've seen that actually happen, where a judge has reserved a case to his or herself. And
it's absolutely worth it doing it in lots of cases. I mean, I think I did a case couple of years back somewhere in the Midlands, and actually it wasn't a judge, it was a magistrate, and we got before the chief magistrate, and she said, I'm very familiar with this case, and she was there from the start, and it absolutely helped us. She knew what was going on, she hadn't read the paperwork, needed to read the paperwork, she'd already done it. It was great.
Makes your life, if you've got judicial continuity, it doesn't have to make your life a lot easier.
Yeah, and they try to do it anyway. You've got a right to it, but once again, there's also the delay is always a consideration.
Yeah, you're absolutely right.
Okay, so next question is: what do I do if I don't like the result? By and large, the answer is live with it. I know it's harsh.
It's harsh. I would, being a little bit more practical, really and truly, if you think that the court has erred in law, in other words, made a mistake in law, choosing my words carefully, then you can appeal.
99 times out of 100, it's not worth appealing though.
It's not worth appealing it, because often what the courts do, not always, but they do, is if they usually dot their T's and cross their I's. So they normally produce a judgment, or you can get a transcript. That's what they do, the judgment. So you can read it, and you've not got grounds for appeal. Yeah, absolutely. The other thing that I would recommend is, if you've not liked a decision, take on board the criticisms that have been made, try and address them, and I would think about applying to the court in maybe 6 months to a year. Once you've addressed them, and do you know, it is absolutely a massive heads up. You know, we get it, that it can be really painful to read these criticisms of you, but you've actually been given a guide about why the court has made the decision it's made, and if there's any negative things, address them. Yeah. So I hope that answers that. Okay, so
What can you do if you asked for the same judge for continuity, but been told the legal advisor hasn't asked for this?
Say that again.
Okay, so what can you do if you've asked for the same judge for continuity, but been told the legal advisor hasn't asked for this?
Right, so just because we ask for judicial continuity, it actually rarely happens. And again, it depends what area of the country you're in as to whether or not.
And what the judge is doing.
Yeah, exactly. So just a kind of broad stroke here, I find that London areas, obviously being a much bigger place, you tend not to see the same judge. In the smaller areas, it's more likely to happen. And even just because you ask for judicial continuity doesn't necessarily always mean you're going to get it.
The simple reason might be availability.
Yeah, absolutely.
You know, if you've got half a day scheduled and the judge that you want is not available for the next 9 months, and they decide it needs to be dealt with in 3 months, you're probably not going to have much luck there. It's all a balancing act here.
Yeah. Yeah.
You know, I mean, we've been there before where we've been in hearings and the judge has phoned the listing office and they're saying, okay, well, what's the next available date for a half-hour hearing? And the judge is doing this.
Yeah.
Trying to find something. It happens.
Yeah, yeah. So often it's a practical issue as opposed to any kind of conspiracy.
And I think, to be honest, I think most judges want continuity.
Yeah,
because it means they don't have to read another big, better set of paperwork.
Yeah, absolutely. Yeah.
Yeah. Okay. Yeah. So next question. What can I do about a biased CAFCASS report?
I think we've kind of covered this because what you can do with a biased CAFCASS report is to object to it and question them at a final hearing.
Yeah. Okay, next one. I want to make a complaint. What do I do?
Okay, so I'll probably get shot for saying this.
I guess it depends who you're making a complaint against, doesn't it, really? If
it's a family law professional, like CAFCASS or local authority or a social worker, this is controversial, but I wouldn't. I personally wouldn't. And I'll tell you for why. Often they investigate themselves, so there is an element of, is it actually worth it if they're just going to investigate themselves?
And you risk just annoying them?
Absolutely. And secondly, in my experience, it makes you lose focus. Because actually your energies are probably best spent in dealing with the elements of your case rather than trying to put out all the fires. And I guarantee that in family law, you're probably going to find a load of people to complain about.
Yeah, yeah. Court staff, judges, solicitors.
People who are helping you.
No, you shouldn't. No, seriously, no. What the point is, the court wants to see that you're engaging with the process, whether you agree with it or not. The court wants to see you taking a constructive role in this. And if you're going to be that person that decides, I'm going to take everyone on, I'm going to get the judge sacked and the court staff, and I'm going to get the ex-solicitor removed, and I'm going to get the CAFCASS officer, and there's a report that says that you're argumentative and combative, you're kind of proving their point for them.
And actually, in getting yourself embroiled into a complaint, you know what, the reality is you get so embroiled in making the complaint, and trust me, I've seen the 50-page complaint letters that people show me, that actually you're going to lose focus and lose sight of why you're there in the beginning, and it just becomes less about your children and more about trying to fight the system. That's the reality of it, unfortunately. Yeah. Okay,
next question. My ex won't allow contact unless I meet their financial demands. What do I do?
So kids are not a pay-as-you-go service, okay? Any non-resident parent has a legal obligation to pay maintenance, and there's a CMS system already set up to deal with that should you need it.
But there is no link in law between contact and finances.
Yeah, so don't create one.
Do you know what? I have heard of some hearings where a judge or magistrate will say to a non-resident parent, well, are you paying maintenance? Yeah. And it's not actually relevant.
Or appropriate.
But I know, this is the thing, bearing in mind that when it comes to court hearings, people will often say anything to justify the decision. So that would be one of the things that people say.
Yeah, it's true. But yeah, just to kind of put the record straight.
Because this is the thing, the broader point is, contact is in a child's best interest or it isn't. It's got no bearing at all on finance. You can hardly say, well, you know what, my ex doesn't pay maintenance and so therefore contact is not in their best interest. That's not the way it works.
Yeah. Right, I think because we're coming up to kind of 20 past, so I just kind of want to take just some time to wrap this up, really.
You don't answer the other question. You've got 2 more questions.
Oh, go on, answer the 2 more questions.
Okay, can I get 50-50?
I'll let you answer this one.
Okay, right. It's a really curious thing that people say they want 50-50 because when you ask them how is it in the child's best interest, they're usually stumped. They'll usually say things like, well, it shows that the children have both parents are equally important in their life. But you know what? It's a huge red flag if you use that in court.
Yeah.
If you use that, what it looks like is you're insisting on about your rights rather than the children's best interests. You know, if you honestly think that your children's best interests are served by a mathematical identical amount of time with both parents, go ahead and argue it. But you know, you're going to be hard pressed. If it's 50-50, why wouldn't it be 60-40 or 70-30? If you turn it into 50-50, you can probably be painted that it's all about you and not about the children.
Now, we are partially playing devil's advocate here because those are the arguments that we've heard in the courts up and down the country, across the land, when a typically non-resident parent wants 50-50. Okay, I think look, it's the 11th commandment. It's not what you say; it's where you say it.
And you know, I would say that if you really do believe that best interests of your children are served with an identical division of time for both parents, I would say work towards it.
Yeah.
Don't ask for it.
Yeah, and you know what? The court, if you are going to go for that, in any event, the court is going to road test your proposals. So
it will be noted, and you will be asked on it. I guarantee it.
Yeah, yeah. So make sure all practical issues are sorted, okay, and make sure that you're not doing it just because you think it's fair, okay? Because very often you'll get painted to kind of be it's all about you and not the child. So
and the family court's not concerned with fairness; they're concerned with the best interest of the child.
Yeah, absolutely.
And if you do consider that fairness, who's it fair towards?
Yeah. So I'm not saying not go for it because you know what? I see loads of arrangements where the time is divided equally between the parents, and actually, you're right. It can send a really important message to a child that both parties are important, and you know, kids do well in 2 homes. I mean, there is absolutely circumstances where kids do thrive in 2 homes. You'll find there's a division because it's family law, so it's grey. Some people have one view, some people have another view. Some people have the view that a child needs a single base and that they'll visit the other parent.
Oh, depending on the judge you speak to.
Yeah, absolutely. And some believe that, you know, they can absolutely have 2 homes and they adapt well to rules. I mean, after all, kids have rules for school, they'll have rules for mummy's house, they'll have rules for daddy's house. And as long as their time can be managed, then, you know, it can work. But just be prepared for the arguments for and against.
Okay, and the last question, it's a great question to wrap up on. Are the courts biased? Can you hear that sound of a large can of worms opening up?
Do we want to go to that now?
I'll let you answer that one.
Oh, thank you. That's a really difficult one to answer because we see so many variants, you know. I think it might be fair to say that the resident parent often feels like they hold the cards, and because the primary carer...
Do you mean the resident parent or primary carer?
Primary carer will have the greatest chunk of the quantum of time they spent with the children, then I think the courts may have a tendency to listen to that a little bit more. But, you know...
Let's say there is actually a structural reason for that as well, because I talked about a no-order principle.
Yeah.
The court doesn't like making orders.
Yeah.
And if you're the parent who has a child for, say, 80% of the time, the parent who has a child 20% of the time, if they want to change it, they need to convince the court that a change needs to be made.
Absolutely, yeah. So often the non-resident parents often have a more of an uphill struggle because of the status quo, and actually the status quo is probably one of the most difficult things to overturn, and that often trickles down to a non-resident parent feeling that the courts might be biased.
Yeah.
So I think that's probably the best I can answer.
Yeah, I think so, yeah.
To put that way.
But you know what? If you do suggest the court is biased to the court,
I wouldn't.
You're not going to convince the court. The judge is not going to say, actually, no, you put it like that.
Yeah, you're
yes,
not
you're biased.
Yeah, exactly. Don't expect a reasonable answer from that.
Okay, so I think we've wrapped up all the questions now.
Yeah, guys, it's been fun.
Do you know? I think we're going to buy ourselves a new microphone for next time.
Yeah. So yeah, definitely.
Okay, so I think we'll finish now.
Yeah.
So we hope you enjoyed it. If there's any more questions, please add them in at the bottom.
Yeah.
We will do more question and answer sessions.
Yeah.
We did get a lot of questions of people via email, and also while we've been broadcasting. It's been really good.
I hope you guys have found it really helpful. Yeah. You know, just to kind of be able to speak to the horse's mouth, so to speak. So...
Horse's mouth. Okay, right. Sorry, I was going to say something rude there.
No, I don't believe it.
Okay, so we'll wrap up now, and we hope you have a good evening, and all the best. We'll see you soon.
Take care.
Bye.
Bye.